Assalamualaikum and a good morning to everybody. Very good, very morning, very early in the morning. I assume Mr. Thompson and Mr. Doty are from England, both of you.
Yes, that's
And
right.
yeah, and Judge Ali is about 10 o'clock. No, he's 11 o'clock. And Justice French and myself, we are ready to have tea now. So, Mr. Thompson, uh, you're ready to proceed on.
Yes, my lord. I think it's probably Mr. Doherty's appeal to go first.
Yeah, sorry. I got the other way around.
Yes.
Yeah.
Can I just say thank you particularly to your lordship and Justice French for sitting later than normal to accommodate Mr. Doherty and I. It's very kind of you to allow us a couple of extra hours. But I think it's probably Mr. Doherty's appeal to progress. So I'll let him go first.
Yes, of course, I got the wrong person. So, Mr. Doty, if you read 46 of the respondent's submission, for paragraph 46 of Mr. Thompson's submission, you will notice, have you got to that page yet?
Yeah, sorry, I'm actually just
paragraph 46.
getting it now, drawing it up now. Yes.
Yeah, he concluded in his submission there are two possibilities. If the court determines that Muhammad and Majid did not have the power qua shareholders to bind the BVI companies, that is the end of the claim. The appeal will be dismissed. No further evidence could save it. 46.2. If the court agrees with the IGPL's thesis regarding Muhammad and Majid's purported power to create tenancy agreement, ground 5 is moot. The appeal will be allowed, immediate judgment set aside, and the matter will proceed to trial. The Al-Saris will be allowed to put further evidence before them. Would you agree this is the conclusion that we should arrive at the end of the hearing, or even now?
No, is the short answer. I'll come on to explain why in a little bit of detail by reference to Justice Giles' judgment. But
okay.
the short point is that they get at ground 5 gets at a slightly distinct issue and a distinct way of framing the application of the Geomatic principle.
Please proceed then. We'll hear what you have to say.
Certainly. Well, your lordships will, I hope, recall some of the background, having already heard submissions on grounds 1 to 3.
Yes.
At that juncture, we were largely dealing with a legal question on authority in the application of the Geomatic principle. As I intimated, this further ground of appeal raises a slightly different issue, which is that in granting the respondent's application for immediate judgment, the judge erred in his approach to the legal principles governing that type of application. And in essence, we make 3 criticisms of the judge's approach. First, we make the fairly straightforward argument that based on the documents and the evidence already placed before the judge, the appellant plainly had real prospects of succeeding in its claim. And in making that argument, I'll take your lordships to some of the factual material that we didn't touch upon fully in the context of grounds 1 to 3, which as I say, was more of a legal question. The second criticism is that we say that the judge has adopted the wrong approach in determining the application for immediate judgment and in his findings on whether evidence could reasonably be expected to be available at trial that was relevant, that was not then available at an interlocutory stage. We say that faced with prima facie documentary and witness evidence addressing Abdullah Al-Sari's authority to sign the tenancy agreement, there were plainly disputed facts requiring further investigation and necessitating further trial evidence. And that's something we in fact say is implicitly accepted in the judge's own reasoning. And in making that submission, I'll also take your lordships, I hope relatively briefly, to some of the well-known legal principles governing summary disposal, and to clearly set out why we say the judge ought to have held that there was a triable issue in this case. And then finally, again, relatively briefly, I'll address your lordships and why the judge's approach to the test in immediate judgment wasn't only wrong, but in fact was punitive in seeking to effectively impose a positive obligation on any respondent to an application for immediate judgment to advance its trial preparation and lay all of its cards on the table at an interlocutory stage. And we say that that approach had no basis on the established legal principles. So that's the overview. That's broadly what we're going to say. That brings me on to the point which you were just asking about, which is the point raised by my learned friend that this appeal is OTOs. As I say, your lordships will hopefully have some recollection of the core facts that are relevant to this appeal. That is the existence of a power of attorney conferred by Majid and Muhammad al-Sari on Abdullah al-Sari, and why it was that we said that that gave Abdullah the power to enter into the tenancy agreement for the purposes of grounds 1 to 3. What we say is wrong about the respondent submission that the appeal on ground 5 is OTOs is that grounds 1 to 3 were in fact addressing a different question. The issue before the court at that juncture was that the judge had failed to apprehend and therefore address in his judgment the primary way which the appellant had put its case on authority. And the narrow legal question at that juncture and at the last hearing was whether the application of the Geomatic principle means that shareholders acting unanimously can directly bind a company vis-a-vis a third party. The issue on this ground is different, and the easiest way to illustrate that is perhaps to look at Justice Giles' decision.
Just before you go to that, just before you go to Justice Giles, Mr. Doherty, you've got in effect, I may be putting words into his mouth, a concession on the part of Mr. Thompson that the only way he wins overall is if the court holds that Muhammad and Majid did not have the power as shareholders to bind the BVI companies, whether by way of Geomatic or otherwise. In other words, if as shareholders acting unanimously, they could not have resolved to authorise the tenancy agreement or could not have resolved to enter into the tenancy agreement, that's the only basis upon which he can win. That's what it seems to me he's saying in 46.
Yes, yeah, so the way that paragraph...
And all the rest of the stuff about the evidence kind of falls away on the correctness of that essentially narrow legal factual question.
Yes, so I think the proper way of analysing this is to say that if the appellant succeeds in grounds 1 to 3, it's correct that ground 5 falls away because we already have decided as an issue of law that Abdullah would have carried the authority to enter into the agreement with Igpl on behalf of the BVI companies. The point we make is that the reverse doesn't hold true, so that if the respondent is successful in grounds 1 to 3, there is still a triable issue that arises from ground 5. So grounds 1 to 3 dispose of the appeal if the appellant is successful, but they don't dispose of the appeal if the respondent is successful on grounds 1 to 3.
But if the basis upon which the appeal is determined, and remember the argument, the shape of the argument changed a little and narrowed a little at the last hearing. If the appeal in respect of 1 to 3 is determined, on the basis simply that the shareholders acting unanimously could not, given the state of the articles and the BVI Companies Act, have authorised the entry into the tenancy agreement, and a fortiori could not have executed the tenancy agreement, assuming that that is the only way he can win the appeal, would there be anything you could say against that?
Yes, and this really has to do with the way in which the question has been framed by Justice Giles in paragraph 49, which addresses a distinct application of Geomatic, which is actually about the formalities itself.
What I'm putting to you is, let's assume that there are various things about criticisms you've made of Justice Giles' judgment, but having regard to the supplementary skeletal argument put at the last hearing, the issues were narrowed. And the issue boiled down ultimately, because you were telling me about unanimous resolutions and so forth, to the question whether the shareholders acting unanimously without altering the articles of association could have authorised the company to enter into this arrangement, or indeed entered into it on behalf of the company. And if you assume that the answer is that narrow, and that's the only basis upon which the appeal could be dismissed, is there anything you would say against that by reference to evidence? Being familiar, as we all are, with the criteria about the grant of immediate judgment where there might be a triable issue of fact, I don't think there's any controversy about any of that. We're thoroughly familiar with that and have read your submissions.
Yes, I would agree that when we're dealing with grounds 1 to 3 and the way the geomatic principle is applied there, we're dealing with effectively a narrow legal question. The issue on ground 5 is that effectively what we would be looking at is a scenario not in which we are considering a shareholder resolution to enter into an agreement with a third party, which is what we were looking at in grounds 1 to 3. But the question would be a slightly distinct one, which is whether separate to that, and this is to an extent on Justice Giles' own framing of the case, whether shareholders could otherwise have resolved that a third party, in this case, Abdullah Al-Sari, could be an authorised signatory on behalf of the BVI companies and therefore execute its formalities on the BVI companies' behalf. And we say that that is a question which does raise factual issues which were before the judge, and is one in which the judge doesn't appear to have had any issue with that analysis being correct in principle. The issue for the judge was that he said that, well, I don't have evidence from Mohammed, Majid and Abdullah, and so I'm going to assume that none is going to be forthcoming. So that's a distinct issue. It's not the question of whether or not shareholders can directly bind the company, it's whether the shareholders could appoint an authorised signatory to act on behalf of the company. They're both applications of the geomatic principle, but the acts that they're authorising are different.
Mr. Doty, could you, at this stage now today, indicate to us briefly what your evidence will be if this appeal is allowed? What are you going to prove factually? Just give some indication.
Yes, my lord, I'm happy to take you through the evidence that was before the court. Effectively, the summary of the position is this, which is, for the purpose of an immediate judgment application, and I know that there are issues on the respondent side about this, but it has to be assumed that what we have, with not only the tenancy agreements, but a whole spate of other agreements entered into during a protracted window, we have a series of documents signed on behalf of the BVI companies, or purportedly signed on behalf of the BVI companies, by not only Abdullah Al-Sari, but other shareholders, to the point that it is clear, we say, that the established practice in the running of this business was that formalities and entering into agreements were habitually covered by the shareholders and Abdullah Al-Sari. They're referred to as the A-list, and I'll come on to this and I'll take you to the documents. And the point there is that if we assume, as of course we must, and of course we say is the only reasonable inference from the documents, that these agreements are genuine, there is clearly some further investigation as to why that was the position over such a protracted period of time. And it's that issue which is something which requires further investigation and ought to have been deferred to trial. So I don't come before the appeal today trying to introduce new evidence. The point we raise is that on the evidence that was already before the judge, there was clearly a tribal issue.
The tribal issue going to power to authorise a transaction which was beyond the power of the shareholders according to the Articles of Association and the company's law?
No, so in this instance, it would be on the framing of the case that says that Abdullah is authorised as a signatory. So it's about the formalities and it's about the evidence which suggests that it was the accepted practice that Abdullah Al-Sari would habitually sign contracts on behalf of the BVI companies.
But he wasn't, his authority could only be as good as the authority of the shareholders, assuming treating Majid and Mohammed as the shareholders for the purposes of this argument.
Yes, that's correct. And then the question becomes, well, what did the shareholders assent to him doing? Now, the first piece of that analysis was based on the broad power of attorney that was conferred, which says that he can stand in their shoes as shareholders and effectively be the directing mind of the company. So he can enter into an agreement as if it was with the unanimous consent of the shareholders. But then the second point of that, which arises from the power of attorney, is that it also refers to Abdullah's power to sign documents. And that goes to this formalities point. So even if one assumes as a matter of law that it's not possible for shareholders to directly contract with a third party, that we would say it's still possible that shareholders could enter into a company resolution that would be binding that person X is authorized to sign documents on behalf of the company.
Well, you kept
material distinction between, for example,
you kept on referring to signing of the documents. Are you contending that these are acts of management that Abdullah has been authorized to do? Is that what you're trying to say? These are acts of management. If you read through the authorities, the cases seems to say that if it is management, it should be left to the directors. Do you agree with that? Those cases? If you agree, then you have to show that Abdullah was signing the document, acting as in respect of management for the purpose of managing the company.
Yes, but of course that normal position is subject to the Geomatic principle. So that goes back to all of the arguments that you will have heard back in January. The effect of the Geomatic principle is that the shareholders acting unanimously can do anything that the company could ordinarily do, as long as it falls within the business that the company is empowered to undertake.
Right.
As the case here.
Right.
It's not quite anything that the company can do, is it? I'm just looking back at CBAN, which you took us to in the earlier argument, which said the Geomatic principle is, in short, the principle that anything the members of a company can do by formal resolution in a general meeting, they can also do informally if all of them assent to it. But that depends upon what the powers of a general meeting of shareholders is. So that Geomatic doesn't extend their powers, it cures informality, doesn't it?
Well, in fact, you may recall that our submission is somewhat broader than that, and we went through a series of authorities on that at the last hearing, which says that as long as an act is intra vires, in other words, is something that a company is otherwise permitted to do in its memorandum of association. So for example, it's engaging in the type of business that a company is permitted to engage in, that the shareholders acting unanimously can do anything to bind the company.
Well, I think that you mean that means there's no authority for the proposition, is there, that the shareholders by unanimous resolution can do something which they're not empowered to do under the Articles of Association without first amending the Articles of Association?
No, because the purpose of the Geomatic principle is effectively to avoid a company getting out of its obligations that it entered into outside of the structure of the company's formalities. It is a purposefully informal rule. So one would say that if the effect of Geomatic was to require shareholders to operate only through the precise terms of the Articles of Association, the purpose of the legal principle would in fact fall away. So what Geomatic does is create circumstances in which shareholders acting informally can nevertheless bind the company, so long as it's an intra vires act. And
well,
what we mean by that,
Mr. Doherty, I'm looking again at the passage from Geomatic, which is cited from in Saiban as part of the encapsulation of the Geomatic principle, where Justice Buckley said, where it can be shown that all shareholders who have a right to attend and vote at a general meeting of the company assent to some matter which a general meeting of the company could carry into effect, that assent is as binding as a resolution in general meeting would be. So it is subject, isn't it, to the powers of the general meeting. And if there's a condition precedent upon the exercise of those powers, purported exercise of those powers, that the Articles of Association permit them, that you're not saved by Geomatic, are you?
no, we say that's not the case. The question is whether or not an act is intra vires the company, and what that means is, as long as you are not engaging in business that the company is not allowed to engage in, the shareholders can bind the company, and they can do that by entering into agreements with third parties. I can dig this out as well. I'll have to go into my other case lines folder to dig out where I refer to that in my skeleton for the last hearing, and the authorities referred to there. But effectively, that is where Mr. Thompson and I disagreed at the last hearing.
Yep. Well, what I was going to ask you is, assuming for the moment that Mr. Thompson's proposition is correct and is put by him as the only basis upon which he can win, is there anything about in relation to evidence that would impact upon that narrow proposition and its correctness?
Well, as it relates to grounds 1 to 3 and the way that the Geomatic principle is said to apply there, the answer is no. When it comes to ground 5 and to this alternative formulation, the answer is yes, because what we're talking about there is not the point of dispute we dealt with at the last hearing. Effectively, the point of dispute there was whether Geomatic extends to allow shareholders to directly bind third parties. Here, it's could Geomatic apply such that there would be a resolution of the shareholders, which would stand as a resolution of the company, effectively appointing Abdullah as an authorized signatory. And we say that that is something which would be within the ordinary remit of what you would expect in a general meeting. So to that extent, there is an issue which raises factual questions, which would need to be dealt with at trial. And perhaps it would assist to just read out the manner in which Justice Giles had framed this.
All I wanted to do, Mr. Doherty, I'm sorry to interrupt, but all I wanted to do was to try and narrow the focus of the argument, because Mr. Thompson has cast very narrowly the only ground upon which he can win. In other words, we don't need to get into other questions which he's not defending in relation to. He's saying the only way on which I get to win this case, if won, and then anything else I lose, and that's 46.2, it seems to me. And so the question for you is, well, assuming the correctness of that proposition, is there anything that in the evidence that could undermine a conclusion that there was no power? Assuming we found there was no power, could you say anything in answer to that by reference to evidence?
But it depends what you mean when you say no power, and this is why we say that this ground is not parasitic on 1 to 3, because the power we're talking about in grounds 1 to 3 is a narrow power. It's can the shareholders bind the company with a third party? And the point about ground 5 is that there is a distinct and different application of Geomatic. And I'll read from Justice Giles' decision on this, which is paragraph 49, about halfway through. He says, apart from the power of attorney, and in the absence of evidence from any of Muhammad, Majid and Abdullah, there's nothing to warrant finding that they informally resolved that it should be signed by Abdullah on behalf of the defendants. Now, it's that final part which is the way Geomatic applies in ground 5. So the primary position advanced by the appellant is this point about shareholders directly binding the company. But what we say is that even if that power doesn't exist and grounds 1 to 3 fail, we still have this question at ground 5 about whether Abdullah was empowered to sign the agreement on behalf of the BVI companies. So that's on behalf of the companies, not on behalf of them in their capacity as shareholders. So
he could only be so empowered. He could only be so empowered if the shareholders had the power to do that themselves, because they couldn't authorize him to do something which they did not have the power to do or to authorize. Could they?
No, I think if I understand you correctly, Mr. Doty, what you are saying is you're talking to Abdullah as a person, not as a shareholder. He's now been authorized by the directors of the company or the companies as directors to sign that. Is that what you're saying? By virtue of practice, the directors have been authorizing Abdullah to sign, and therefore you are saying Abdullah can sign on behalf of the directors in these circumstances. Is that what you're saying?
It's slightly distinct from that. So it is still an application of the Geomatic principle, and what it would say on this framing of the case is that it would be open to the shareholders at a general meeting to seek to appoint, amongst other things, directors, or for example, if there was a shareholder resolution seeking to appoint an officer, or in this case, an authorized signatory of the company. If that was the case, what we say is that Justice Giles didn't seem to have any problem with that being something that could happen in principle. His issue was that there wasn't enough evidence at an interlocutory stage for him to make that finding or to proceed to trial. And we say it's that part of his judgment in this.
Yeah, but Mr. Doty, if you're going to proceed to trial, if you can, just as I said earlier on, indicate to us what are you going to prove at trial factually. I know I'm asking for details. What are you going to prove at trial that will help you? But you cannot even mention that to us. And perhaps that's why Abdullah and Majid and Muhammad didn't file in any affidavit at all at the interlocutory stage.
No, that's not the way that we would put our case. And what we say is that there was ample documentary evidence, not least for an interlocutory stage where we're dealing with thresholds on immediate judgment, that show that it was understood that Abdullah was able to enter into these agreements. And once one accepts that those agreements are genuine and that they were signed by Abdullah on the date they bear, there is plainly, we say, calls for a full investigation at trial. And we say that that is clear from the authorities on immediate judgment about which types of cases are and are not suitable for immediate judgment. And we say that this is the sort of case that falls squarely into the bracket of requiring trial.
Are you saying that you don't have the documents earlier on? Now suddenly you have those documents?
No, we do have the documents. I'm happy to run through those now because we didn't go through them necessarily during grounds 1 to 3, which, as I say, was a narrower legal issue. But if it would assist, I'm happy to run through what we say the facts before the judge were and why that.
Okay.
What's
Go
the
ahead.
proposition? Sorry, Chief.
I see this differently from what you say. Anyway, what do you want to say, Robert? I'm sorry to interrupt.
Sorry. The factual proposition you seek to extract from the documents to which you would refer is that there was a practice of Abdullah signing contracts purportedly on behalf of the company. Is that Mr. Doherty?
Yes, there are a few strands to it. That's the primary strand, and we have 3 separate instances over a 5-year period where that's the case, including one instance in which the Court of Appeal in Sharjah has found that to be a binding agreement. And then there are other parts of the evidence which go to the practice of the management of the companies generally via Abdullah and the shareholders. And this is the evidence from Mr. Colin Denvers in his witness statement.
First, well, I guess from our point of view, it would be sufficient to assume that you are able to establish such practices without necessarily getting into the evidence. The question is, what difference does that make if the first proposition put out, or the first option put out in Mr. Thompson's submission at 46.1 is good? Because that's the only basis on which he can win, he says.
Yes, but the way it's put by my learned friend at 46.1 is if the court determines that Mohammed and Majid did not have the power as shareholders to bind the BVI companies, that is the end of the claim. We say that's not the case because the question we're dealing with here isn't whether Mohammed and Majid have the power to bind the BVI companies. It's whether they have the power as shareholders to pass a resolution authorizing Abdullah as a company signatory. So it's a different question. It's the operation of a different power. And in paragraph 49 of Justice Giles' judgment, he didn't question the framing or the conceptual framing of the Geomatic principle when it came to authorizing Abdullah as a signatory on behalf of the BVI companies. So that's the point there. The first instance judge did not say that that case was bad at law. He just said that the evidence wasn't there.
But the anterior, that is the anterior question, isn't it, of power? And that was debated at the appeal.
We would say that that wasn't debated during grounds 1 to 3 because we were dealing with there a specific and narrow legal question, which is very much this question of whether or not shareholders directly bind the company. And we say that under Geomatic they do, and that is our primary position, and that is the end of it if we're successful there. But then that comes on to a secondary question on ground 5, even if the appellant is unsuccessful on grounds 1 to 3. And that's why we say that it's not parasitic and it doesn't fall away if the respondent is successful on ground 5, on grounds 1 to 3, because there's still a triable issue once we get to the end of that.
Anyway, you've encapsulated the factual propositions which you say can be derived from the evidence upon which you would rely, or which was before the judge.
Yes.
Yeah.
That's right.
Okay.
And I think it might assist if I take you just to those documents so we can see what we're talking about and what we can see in the round as having been the evidence before the judge. If you're content to proceed on that basis, the starting point, we would say both chronologically, but when it comes to questions of Abdullah's authority, generally is the power of attorney. And you were referred to it at the last hearing, but it is with respect to an important document, so I think it might be worth pulling up, but it's in the core documents at tab 2. And then within that, it's tab 3 and page 14.
Yep.
And so there are two parts to this. As I say, I took you to them at the hearing of grounds 1 to 3. You'll note at the outset, of course, the date of this document is 26th of June 2008. So we're talking about a document that is created some 4.5 years prior to the tenancy agreement being entered into, and around 10 years before the Commercial Bank of Dubai obtained its judgment against the shareholders in the BVI courts. So we're not talking about something here where there can be any serious question that it's a document designed somehow to frustrate the Commercial Bank of Dubai a decade later. Clearly, the sole intent of this document is to set out the terms in which the shareholders authorised Abdullah Al-Sari to act on their behalf and in a range of different capacities. And the question before the first instance judge is whether the power of attorney is prima facie evidence that Abdullah was authorised to enter into the tenancy agreement. And there are two aspects to that. First is at the beginning of this power of attorney, which says that it empowers Abdullah to represent us and take our place with absolute power to transact by way of sale, purchase, and acceptance of purchase of all movable and immovable assets, real estate properties, and land of various types, vehicles, all properties registered in our names, and all institutions of various types belonging to us in our capacities as owners and partners thereof. So that's anything the shareholders could have done as shareholders of the BVI companies, Abdullah can do. And that was really at the core of the appellant's submissions when it came to grounds 1 to 3. And then further down, and again, your lordships have seen this before, in the context of this broad power of attorney, we also find reference to Abdullah being given the authority to, and I'll read this out because it's hard to find in this document, to sign all documents without referring to us. And we say that part of the power of attorney is clearly important in the context of this alternative geomatic question, which is whether the shareholders resolved that Abdullah was authorised to sign the tenancy agreement on behalf of the BVI companies. Now,
before you proceed, Mr. Doty, you are saying that the shareholders have authority under the memorandum and the laws to decide on what tenancies to enter into. That's what you're saying.
Our primary case, grounds 1 to 3, is that the shareholders have the power directly to bind companies with a third party. That's formulation number 1. Formulation number 2 is that the shareholders also have the usual powers that shareholders have to make resolutions regarding the company's management.
And that you say that includes entering into tenancies.
That includes authorizing Abdullah to be allowed to sign to execute company formalities on behalf of the BVI companies. So the point is that the shareholders could have, if they chose to, pass a resolution at a company general meeting authorizing Abdullah to sign the tenancy agreements. That resolution would then, by an application of Geomatic, have become binding on the company, and that would have then meant that when Abdullah signed the tenancy agreement, he was signing it on behalf of the BVI companies, and thereupon it becomes a contract entered into by the BVI companies. So that's the alternate hypothesis that we're discussing here when it comes to ground 5.
My dispute is whether signing tenancy agreements in the circumstances of your memorandum and the laws of the BVI company includes signing of tenancy agreements. Is that not an administrative responsibility rather than the shareholders' power?
Yes, but the point that we raise on this formulation is that the shareholders can resolve that company administrative acts be carried out in a particular way. So as long as the shareholders are resolving to do some kind of...
But if you want to show that, then you have to show you have to show what does the memorandum of authority says and what the law says. But what we see from Roger Giles' judgment was that it's not. That is not so, because the powers of the AGM is only limited to certain things. They can, and that does not include doing administrative management work or responsibility. That's how I see it, at least.
I think that we disagree with that categorization of the issue, because what we say the point of principle in Geomatic is that the shareholders, as long as you're doing something that the company is permitted to do.
No, don't go into Geomatic yet. Don't go into Geomatic yet. Geomatic comes into play if the shareholders have that power. Then, by virtue of Geomatic, they can have that power. They can do anything, even though they do not formally comply with the requirements of how they pass the resolution. That is Geomatic. Yes. But if they don't have that power first at the beginning, they don't have that power to enter into tenancy agreements, then doesn't matter Geomatic or not, they can't do it. Even if they do it formally, they cannot do it because they don't have the powers to do that. That is what is going in my mind now.
But on this analysis, what we are not saying is that Abdullah is signing on behalf of the shareholders. What we are saying is that Abdullah is effectively standing in the shoes of someone who has been authorized to sign a legal document at a general meeting.
In other words, he's standing on behalf of the corporate directors. That's what you're saying.
He's signing on behalf of the company. So it is as an administrative act, and that the reason that is valid is because the shareholders have informally resolved that he can do so, and that becomes binding on the company.
That's what you're going to prove at trial, if you're allowed to.
Yes.
That the shareholders are going to say, shareholders going to say, our practice had been for the BVI companies to accept what Abdullah does as their own decision, right? The corporate directors has been accepting what Abdullah has been doing as their own, their own acts.
Well, that is part of the factual matrix.
Yeah.
That's why we say that there's a triable issue here.
Yeah. You have to prove that. You have to prove that.
I think the distinction is that the analysis isn't quite the same as traditional cases on implied authority, because the way you get to authority in this instance is actually still through an application of the Geomatic principle. It's just a different application. So we're not saying in this instance that it's implied through the acts of the directors that they had authorized Abdullah. The way that you get to authority is still through shareholder assent to that course of action, to that formality. But the factual issues behind both are the same. And to that extent, what we're dealing with, and I'll come on to this in due course, is questions of mixed fact and law. I'll come on to the case of Phipps in a little while, which are complicated and are issues which are properly for trial. But the important point for present purposes, we say, is that there's enough evidence that was before the first instance judge for that investigation to need to take place and for a trial to need to happen. And courts should be exercising a good deal of caution about entering immediate judgment in cases like this.
I think Judge Ali and Judge French will just allow Mr. Tohoti to proceed on with his submission, and because I think the last half an hour we have been going around in circles on the same issue over and over again. So, Mr. Tohoti, I think we'll hear what you have to say. Give
Yes,
you an
well,
opportunity.
Well, hopefully we can circle back to the end and we can try to hammer out the issue. Really, it's the fundamental point is the distinction in the application of Geomatic, and we say that one of the reasons the distinction arises is what we've just looked at in the power of attorney, because we're not talking about a power of attorney which solely deals with Abdullah acting in a broad capacity to act on behalf of the shareholders, including in relation to acts of the companies they own, but that he is also then being empowered to sign all documents on their behalf. So we're talking about there being provision in this power of attorney for Abdullah entering into certain formalities on their behalf, and that's what triggers this second analysis. And what we say is the power of attorney is evidence in itself that should give rise to a triable issue. And one of the reasons we say that is because Justice Giles appears to have said that himself. So if we look at what he said in paragraph 49, he says, apart from the power of attorney, and in the absence of evidence from any of Majid, Mohammed and Abdullah, there is nothing toward finding that they informally resolved that it should be signed by Abdullah on behalf of the defendants. The first subclause of that sentence is important because it necessarily accepts that the power of attorney itself was prima facie evidence that the shareholders had informally resolved that Abdullah was authorized to sign. And the issue for the judge at first instance wasn't a question of principle. It wasn't a question of the application of Geomatic. That seems to have been accepted by the judge, or at least it had been accepted by him for the purposes of surpassing the threshold on an immediate judgment. But what he's taken issue with is the propensity of evidence that was available at that stage. And what he said, going on to paragraph 50 of his judgment, is that having not led evidence from Abdullah, Majid and Mohammed, he sees no reason why the appellant should be offered the opportunity to improve its position. And we say that that approach is wrong in law, because once one gets to the point of seeing that there is that prima facie evidence of that authority existing, the question becomes one for trial, because there is a reasonable expectation that further evidence would become available. But before I come on to those points on the law and the proper approach to immediate judgment, it's worth pointing out that it's not only the power of attorney that was before the first instance judge in this case. Again, taking them in chronological order. So after the power of attorney, we also have a letter, 12th October 2011. It's at bundle tab 6. It's page 1301. Which is in tab, it's in tab 15, so it's bundle 6, tab 15. Which is about 3/4 of the way down in case lines. It's page 87 of 122.
What was the page again? Sorry.
So it's 6-1301.
6-6
1301.
1301. Okay.
I think that's tab 23, is it?
Tab 23.
Sub tab 23, yeah.
It may be that my bundle is showing
It's SJ23 to the affidavit, SJS3 to the affidavit of Sarah Jane Sheffield. Is that the one?
I'm looking at NCD 1,
Oh,
which is tab 15.
tab 15. All right.
Tab 15, you see? Tab 15. What is the page? The page number? Can you give me the page number?
So the page number on the top right is 6-1301.
Okay, 6-1301.
And within tab 15 is page 87-122.
1301. Okay.
Mr. Doty, I'm afraid there is no 1300 number in that tab. It's only start with sorry, 11. It's 1100 and something.
In so
1301. Yeah. Quds is headed by Quds. The word
That's
Quds,
right.
is that?
yeah,
Quds.
What page in your
This
bundle,
one.
Chief Justice?
Yeah, 61301.
1301.
61301.
it may be that your lordship has the case lines bundle open from the previous hearing.
Yeah.
Okay.
Yes, I think that's what I was doing, Mr. Doherty. Into CA 13.
So I think the simplest way is to come out of that and open up the other bundle that's available for CA 15-2021.
Yes, it's under tab 17 with me in the new system. I got it.
New system, tab 17. Oh, don't
I
confuse.
yeah, I mean,
I've got 61301. Don't disturb me.
Yeah.
I'm not going to get confused again. 61301, 302, 13132. Yeah, okay. Mr. Doty, can you proceed?
Yes, so this is what we say is the first in a series of documents showing that over a prolonged period of time, the habitual practice of the companies is that the A-list, as I'm going to call them, are signing and executing documents on behalf of the company. So in this instance, we've got a letter from Coutts Bank. It's a loan offer from the 12th of October 2011. And what we have 2 pages over is the acceptance of the loan offer being signed by Mohammed Al-Sari in this instance, underneath saying for and on behalf of Westdean Limited, so that's one of the BVI companies. And then the other signature in that document is from Mr. Hurd, so that's one of the directors of AIR. And as I say, the significance is that we have yet another example of shareholders standing in as signatories for the company. And to that extent, we say that the tenancy agreement is not.
Yeah, but here, Mr. Doty, there's a signature of Mr. Hertz you mentioned just now. It's not just Abdullah personally, alone.
Yes, the point is that we have the shareholder signing for and on behalf of Westdean Limited. So effectively standing in on the understanding that he is permitted to sign in the same way that a director is permitted to sign. And that raises the question as well, why is that the case? And it's to that extent, as I say, we're saying the tenancy agreement is not the exception. In fact, it's the norm. And the BVI companies are consistently acting through the A-list when it comes to satisfying legal formalities. And for what it's worth, that's an approach which also appears to have been acceptable at the time to Coutts Bank. The second document, which I think goes to the same point, is from a couple of days later. It's it's a letter from Mr. Colin Denvers. Sorry, I've jotted down the wrong page reference. It's in the same tab that you currently have open.
What page is that now?
Yeah, bear with me. It's at 1322.
6-1322. Okay.
So I don't want to interrupt Mr. Doherty but if he's moving on from that document, I just wondered where it is we obtained the confirmation that that's Abdullah's signature. I didn't see a name on it, but if Mr. Doherty doesn't want to show us that, I'm not sure where he gets his evidence from. It doesn't look like his other signatures.
I can take it. It's not Abdullah's signature, it's Mohammed's signature. We went through the documents which show that it's Mohammed's signature at first instance. I can dig that out and go through it now. It wasn't an issue before the lower court. I believe it might have been dealt with my skeleton then, but I can dig out those references and take you through.
Sorry, I thought you said it was Abdullah's signature.
No. At 1322, we then have this letter from the 14th of October 2011, which perhaps provides some more context for how this document has been signed and how documents are signed generally. And this is a letter from Mr. Nicholas Cohen-Denvers. This is also something he speaks to in his witness statement. And what we can see being requested in relation to the loan documents is that they're signed by one of the A list. That's one of the shareholders or Abdullah, and then one of the B list, which is the heir directors. And the important point here, and the important point from Mr. Cohen-Denver's evidence, is that the normal practice as far back as 2011 here. So again, well before we're talking about there being prospective enforcement proceedings in the BVI, it is understood that Abdullah is authorised to sign legal documents on behalf of the BVI companies, and there's certainly no evidence that I'm aware of that heir or the directors of heir ever questioned that, which again we say necessarily invites investigation as to why they were satisfied that Abdullah stood in the position of being able to sign those documents for on behalf of the company. The third piece of evidence going forward a couple of years, and I don't need to take you to it, but it's the 16th of January 2013 and the tenancy agreement itself. So this is, I think, more than 5 years before the Commercial Bank of Dubai is seeking to execute its judgment. And for your note, it's tab 2, page 7, but we find that the signature page demonstrates Abdullah Al-Sari signing those agreements on behalf of the BVI company. So this, we say, is yet more documentary evidence which suggests that Abdullah, at the very least, has understood that he can act in that capacity as a company signatory. And we say that's consistent with the position outlined in Mr. Cohen-Denver's letter and in his witness evidence. It's also consistent with Mr. Cohen-Denver's evidence in his witness statement in paragraphs 21 to 24, that heir played no significant role in day-to-day management of the BVI companies. And again, one would consider that that invites investigation as to why heir, as the company director, was content not to have an active hand in the management of those companies over such a protracted period of time. In this period, it's not, of course, only the tenancy agreement. We have a second agreement signed by Abdullah on behalf of the BVI companies in the addendum agreement. And this isn't an issue which is only arising in one specific period of time. So jumping forward, this is in bundle 6, page 146.
Give me the page number again, please.
Bundle 6, tab 2, page 146.
6146. Is that it? 6-146?
That's right, I hope.
6-146. 6-146. Why do you go elsewhere? It doesn't go to 146.
I might have got my reference from the other as well.
Different page. It goes to 356. I keep on putting 6. It goes to 356. 6 dash 1 4 6. It goes to different page. It goes 356.
You're right. That is the wrong page reference. Bear with me. I'm looking up the correct page reference. I'll dig that out for you when I've finished my submissions. Perhaps I'll just tell you what the document is, and we can go back to it later if we need to, and I'll get the reference. But this is a settlement agreement dated the 1st of November 2018 between a company called Globe Investment Holdings with the BVI companies. And I don't mean to dwell on any part of the agreement itself. This is the agreement which is in issue in the Sharjah proceedings and which has been upheld as being valid by the Sharjah Court of Appeal. The respondent's own position on that is that this is another example of being a sham agreement, but of course that's not a question for summary disposal. The assumption for present purposes must be that this is a genuine agreement. And with that in mind, what we find then in 2018, so this is 5 years after the tenancy agreements have been entered into, is another agreement signed by Abdullah Al-Sari on behalf of the BVI companies.
Were these
I think
before
6-416. Sorry.
Again, sorry, I beg your pardon, Mr. Thompson. What was it?
I was just going to give you the page reference. I think it's
Yes,
6-416 or page 608 of the bundle.
Dash 6416 dash 416. Okay, got it. 416. 416. Okay.
So bringing that together, in my submission, we're not talking about there having been no evidence, or even for that matter, a single piece of evidence before the judge, giving rise to a more than fanciful case that Abdullah had the authority to enter into the tenancy agreement. What we actually have is witness evidence stating that the BVI company's director played close to no active role in its management, and that the usual process for executing formalities on the part of the BVI companies included documents being signed by the A-list. We have a contemporaneous record setting out that A-list process, and the fact that Abdullah Al-Sari was not only understood to have been able to sign documents on behalf of the BVI companies, but we actually have evidence then of him doing so over a protracted period of time and well before there was any prospect of an executed judgment before the BVI courts. We have 3 separate occasions in which Abdullah has signed those contracts. And what we have on top of all of that is a power of attorney, which on its face empowers Abdullah to act for the shareholders in a broad capacity, including in respect of the companies they owned, and to sign documents without referring to them. Now, it's a trite point on the law, but it bears emphasis that the hurdle that an applicant needs to overcome on immediate judgment is set deliberately high. And the judge only needed to be satisfied that the appellant's claim was one which was more than merely arguable and not fanciful. And we say that there was more than enough in the evidence before the judge to disclose that the appellant had real prospects of success when it came to this formulation of the Geomatic principle and the question of whether Abdullah had been so empowered by the application of Geomatic to sign companies on behalf of the BVI, to sign documents on behalf of the BVI companies.
But is this something allowed by the BVI law? I thought there's something, this is not allowed by the BVI law.
Well, the BVI law on this point is effectively the same as English law when it comes to the application of Geomatic. And as you might recall, Siban itself was a BVI case.
No, I'm talking about at the introduction, there was a quotation of the BVI, what provisions of the Company Act of the BVI. Remember, in Roger Giles' judgment, he quoted the judgment, the provision of the BVI law, and say that what you're doing, it's against, that's one of his reasons for holding it against you.
There was a specific point of BVI company law that had been raised during the first instance, but it had been dismissed by Justice Giles because it was an issue that had already been looked at and dealt with in the Siban case. So I don't understand the judge to have been saying that there's a specific reason under BVI law as contrasted to English law as to why the analysis doesn't work. Ultimately, the question is, does this case work on an application of Geomatic? And that perhaps brings me relatively neatly on to the points we raise on the law. So even if we say that the evidence available to the judge at first instance left open questions, that then raises the question of what the court is supposed to do in those circumstances, whether it's proper to enter judgment or whether it's proper to allow full investigation of the facts to take place through normal case management, so production of documents, witness evidence, and so on. And the importance of that in the context of a Geomatic case, we say, is clear. And on that, we refer to, it's a Geomatic case, EIC services and FIPS. It's a case that was in fact referred to by Justice Giles in his judgment. And you can find in Bundle 9, which is the claimant's authorities.
Yeah, but again, this is the powers of the shareholders, the shareholders' powers.
That is a point of principle which is summarised in FIPS, but that's not the point that we're relying on in this context. But if you go to Bundle 9, tab 5, it's page 102 is the beginning of the judgment.
Bundle 9, tab 5, Bundle 9 dash
102.
102. Okay, 9-102. Okay.
And so, looking very briefly, first of all, at paragraph 2. This is a judgment from Mr. Justice Neuberger as he was then. And halfway down paragraph 2, you'll see a sentence beginning issue 2. And what he says is issue 2 involves questions of fact and law, principally relating to the applicability of the so-called Geomatic principle. So the point to arrive there is that we're not talking about the application of a short point of law in isolation. We're talking about a question which is a mixed question of fact and law. And we can see that more clearly if we go forward in the judgment to it's page 130, paragraph 122.
Bundle page?
130. 130.
130.
That's right.
Okay.
And it's the third sentence of paragraph 122 is where this starts.
I don't know what you.
The first part.
I've got the paragraphs all different. I've got 44, 45. You are referring to a completely different set of paragraphs. You know, earlier on was the same.
I'm
typing
bundle
exactly
9,
what
130.
Yeah, this is what I did. 9-130. Find page. But it goes to a different page. It goes to page 130. 130 speaks about Mr. Hapgood realized on the same submission. That's what it says there.
Is this the EIC services and FIPS case that you were looking at?
I'm just punching the page that you asked me to go, and page 9130 starts with Mr. Hapgood says 9 plus 130. And it says, paragraph 76, Mr. Hapgood relies on the same submission. I didn't get what you're referring to. I'm sorry, Mr. Doty.
The page reference for me is 9130. I think perhaps the easiest thing for me to do is probably to read out.
Can somebody help? Some secretariat? Can you all
CJ,
help?
CJ, if you can try 9-88.
9-88. 9-88. Nine dash 88. I get to page 121. Paragraph 121. Is that it? Not as well.
What paragraph you're referring to?
Paragraph 121. The principle in which this first secondary relies is the name in Geomatic. Is that it?
Yes, you've got the correct page.
Okay, then it's 88. It's not 130. Oh, the master is 130. Current is 98. Mr. Doty, either you refer to the current or to the master.
I don't have a master on mine. I've only got the current.
but you gave me the current as 130, but the current is actually 88.
Oh,
okay,
please continue. I'm not sure.
Please continue.
Yeah. So it's the third sentence. It begins the third sentence of paragraph 122, which begins with a short summary of the geomatic principle. Yes, the principle, as I see, is where the articles of the company require a course to be approved by a group of shareholders. That requirement be avoided if all members of a group, being aware of the relevant facts, either give their approval to that course or so conduct themselves as to make it inequitable for them to deny that they've given their approval. And then really the bit that bears emphasis for present purposes is whether the approval is given in advance or after the event, whether it is characterized as an agreement, ratification, waiver, or estoppel, and whether members of the group give their consent in different ways at different times does not matter. So the point here is that we aren't dealing with a short point of construction or a straightforward question of law, or even, for that matter, a straightforward question of fact. Instead, Phipps makes clear, we say, that we're dealing with complicated questions of fact and law, and some of those are spelled out in the judgment. The questions that can arise are, have the shareholders, first of all, given their unanimous approval to a particular course? If so, when, as a matter of fact, was that approval given? Was it before or after the event? And this authority tells us it can be either. How was the approval given by the shareholders? Was it simultaneously or did they give it separately? Is it something that can be characterized as having been agreed in advance or at the material time? Is it something ratified by the shareholders in retrospect? If the shareholders' approval wasn't even expressed, is it instead something to be inferred from a particular course of conduct? And how does one classify that course of conduct? Is it a waiver? Is it an estoppel? Is it something else? The point is that those are all complicated questions of mixed fact and law, and they're not questions that we say which are suitable for immediate judgment. And one of a number of authorities we say for that proposition is, if your lordships look at the Equitable Life Society and Ernst & Young case, which I'm going to set out the page numbers, but it's in bundle 9. I've got it as page 66. It should be tab 4.
9
tab 4.
66. 9-66. Current. Is that correct?
Yes.
In this connection, there is no special way which shares may be paid up.
Yes,
is that how the page starts?
Yeah, it should be paragraph 38 is what I'm looking at.
38. Yeah, I heard evidence from Miss Jacqueline Thompson.
No, I think that might be a different case as well. It might be easier to navigate using the tabs at the side in bundle 9 if you look for the authority Equitable Life Assurance.
Okay. Skeleton, where's the authority list of cases? The application, witness, and respondents, legal authorities. There is respondent, claimants, legal authorities. Okay, what number is that? What number of the claimants? I got a list of 12 authorities that's been filed.
Yeah, it's in my list. It's the 4th authority.
Number?
Number 4.
Swain again Hillman.
It's above Swain and Hillman in mine. There are 2 number 4s in mine, unhelpfully.
Swain again Hillman. I think we are very, very, very familiar with Swain again Hillman.
It's not Swain and Hillman. The case is equitable life assurance.
Equitable life insurance. Equitable life insurance is not here. Equitable life is number 6. Okay.
Okay. My
Equitable
number
life insurance against Ernst & Young.
Yeah.
Okay, number 6 on the list. Okay,
yeah,
then.
in paragraph 38,
Please.
that judgment.
Yeah, please. Now, where do we go? What page? What paragraph?
Paragraph 38.
38. 38. Yeah, I got it. In 3 Rivers District Council against Bank of England.
Yeah, and the sentence I'm referring to is about halfway down that paragraph, beginning with the overriding concern.
Mm.
And what's said there is that the overriding concern is in the interest of justice. So far as facts are concerned, the simpler a case is, the easier it is likely for a court to be able to take a view that the basis of a claim is fanciful or contradicted by all the documentary material on which it is founded. More complex cases are unlikely to be capable of being resolved in this way. There is a danger of injustice in seeking to try such cases summarily on the documents and thus without disclosure and oral evidence tested by cross-examination. It should not be done unless the court can be confident that all the relevant facts had already been satisfactorily investigated. The power of summary disposal is not intended for cases where there are issues which need to be investigated at trial. And the appellant's point is that immediate judgment should be reserved for those cases which are not suitable for trial at all. And where there are disputes of fact, that needs to be resolved by further investigation. And the court needs to exercise a great deal of caution. And that's the principle derived from Doncaster Pharmaceuticals, which is one of the authorities relied on in the well-known Easy Air judgment. For your note, I've got it at 9160. It might assist if I simply read out the relevant parts. But what the court in that case said was, it is well settled by the authorities that the court should exercise caution in granting summary judgment in certain kinds of case. The classic instance is where there are conflicts of fact on relevant issues which have to be resolved before judgment can be given. A mini-trial on the facts, without having gone through normal pre-trial procedures, must be avoided as it runs a real risk of providing summary injustice. In my judgment, the court should also hesitate about making a final decision without a trial, where even though there is no obvious conflict of fact at the time of the application, reasonable grounds exist for believing that a further investigation of the facts would add to or alter the evidence available to a trial judge, and so affect the outcome of this case. And really that ties into the error in Justice Giles' reasoning in this case, because what the authorities demand is that where there is sufficient material at an interlocutory stage, that fuller investigation is warranted, and that it can be reasonably expected that there should be more information available at trial, and it's worth stressing those words. The proper course is to dismiss the application. Now, the error in the judge's approach seems to have been that he's got that question the wrong way round, because what he's saying when he says absent evidence from Mohammed, Majid and Abdullah is that he isn't looking at the evidence that can reasonably be expected to be available at trial. What he is concerned himself with is the evidence that he reasonably expected to have been made available at an interlocutory stage. But that, as a matter of law, gets the principle the wrong way round. And that brings me on to the final aspect of that, which is Justice Giles' error in effectively seeking to sanction the appellant for not having all of its evidence available at an interlocutory stage. And what he said was that there was no reason to give the appellant the opportunity to improve its position. But that is a punitive standard which expects a respondent to effectively expedite the preparation of its case, to make all of the evidence that it would otherwise make available at trial, available at a very early stage of proceedings. But it's also just something which is, we say, fundamentally wrong, because the purpose of the way the test is framed on summary judgment is to expressly acknowledge that further evidence ought reasonably to be considered to be made available at trial. And it's implicit in that of course, a respondent to that sort of application should be properly permitted to improve its position from where it is at an interlocutory stage to where it would be at trial. And that includes the preparation and collation of documents, that includes the preparation of witness statements, and that's moreover the case where we're dealing with something which addresses complex questions of both fact and law, and which we say are inherently unsuitable for a summary determination. And so what we say is that the judge's decision there is wrong in principle, it's unnecessarily punitive, and on that point, I briefly address your lordships on some of the authorities relied upon by the respondent in this case, I think which it suggests are somehow some kind of legal foundation for the approach that the judge did adopt here. The first is what we say is a selectively quoted extract from the ICI case, and that's at paragraph 28. Sorry, my lords, do you have me? I think I might have disconnected briefly. Sorry, can I just check that you were able to hear me now? Yes, thank you. So the ICI case, paragraph 28 of the respondent's skeleton argument, and what it suggested there is that a case should not go to trial purely on the basis that something might turn up. We have a couple of points on that. First, it's simply not what the appellant is arguing here. We say that there was, before the first instance judge, already prima facie evidence that Abdullah had the authority to sign the tenancy agreement. That set against the fact that there was no evidence from the respondent at an interlocutory stage capable of displacing that or capable of supporting its evidence effectively that these were sham agreements, that wasn't an issue that could be dealt with at that stage. And so the appellant's position isn't that we're talking about production of some unknown or unquantifiable evidence that simply might turn up, but that at a trial we would have the opportunity to present witness evidence that speaks to the documents already before the first instance judge setting out that prima facie case and explain the important context of those circumstances that lie behind the signing of the tenancy agreement and other agreements during that protracted period of time. The second point we raise about that is that it doesn't appear in the quote set out by my learned friend in his skeleton argument, but if one goes to the ICI judgment, I have it as tab 10, or bundle 10, tab 7, page 186.
Page 151 under the current bundle, Chief Justice and Robert.
77151, is it? What is the one? Again, can you repeat, Judge?
Bundle 10.
10.
Tab 7.
Tab 7.
Yep. Page 151, yes.
151. 10.151 ICI chemicals, okay.
Thank you. So the crucial paragraphs here are effectively 11 and 12, which sets the context for the judgment in this case, which is that the first of these arguments, so the point they're dealing with this case, raises a short point of construction which on the face of it, court could conveniently decide on an application of this kind. Indeed, the judge invited the parties to agree that it should decide it as a preliminary issue, but they were unwilling to do so, because on the judge therefore proceeded in the footing that's necessary for him to decide whether there's a real prospect of success. And then at 12, in my view, the judge should have followed his original instinct. It is not uncommon for an application under Part 24 to give rise to a short point of law or construction, and if the court is satisfied that it has before it all the necessary evidence for the proper determination of that question, and that the parties have had an adequate opportunity to address its argument, it should grasp the nettle and decide it. The reason is quite simple. If the respondent's case is bad in law, he will ensure that no real prospect of succeeding. And then it goes on to 13 and it talks about those cases where one has an issue of construction, but the respondent seeks to persuade the court that it should go to full trial by arguing in due course. Evidence may be called that will shed a different light on the document in question. In my view, however, any such submission should be approached with a degree of caution. So the point here is that where one is expecting a respondent to produce the sort of evidence that the respondent on this appeal is suggesting should have been provided by the appellant, we're talking about a completely different category of case. We're talking about issues of construction, which primarily are decided based on the provisions of a contract, and it's only in pretty rare circumstances that the facts are even going to be relevant to that. And so that's important context for that judgment. And insofar as my learned friend then goes on to say that, well, ICI is a principle of general application, in making that submission, it relies on another case, Lit Securities, which I have at tab 6, but it's also referred to, the relevant extract that I'm going to refer to is in my learned friend's skeleton argument anyway. It's at paragraph 29. But what it says is, and the point that I think my learned friend is trying to raise here is he says that once you have a burden that shifts effectively to a respondent on summary judgment, where the appellant's case is that in fact the respondent's case is fanciful, and whenever a summary judgment application turns in the proper reasoning document or short point of law, it is for the respondent to either put before the judge hearing the application the evidence which it says is relevant to the issues being determined, or to show that there is further relevant evidence which can reasonably be expected to be available at trial. It's not enough for the respondent to claim without foundation that there may be further evidence which will emerge in disclosure and under cross-examination. Well, a couple of points there. One, for the reasons I've already taken you through, we say that we have given sufficient reason to believe that that evidence will be available. But the important point is that this judgment also makes clear that this isn't some widely applicable authority for placing the burden on a respondent to front up all of its evidence at an interlocutory stage. It makes it clear again that the context in which this applies is whenever a summary judgment application turns on the proper meaning of a document or a short point of law. And we say that both on issues of law, but also on questions of fact, this is a case which is very far removed from that sort of scenario. And of course, one then also needs to take into account the wealth of other basic statements of principle that the court needs to have regard to, and indeed some of them were referred to by Justice Giles in his decision, albeit we say they weren't properly applied, which is that immediate judgment should not be a forum for conducting a mini trial without disclosure and oral evidence. It logically follows from that the judge should not expect all of the evidence to be available at an interlocutory stage, nor is it incumbent on a respondent to condense and bring forward all of its trial preparation in order to meet that sort of application. As the judge also pointed out, the court should not be attempting to resolve clear conflicts of fact, which are normally resolved by the trial process. And importantly, the court has to take into account, as I said earlier, not only the evidence before it, which we accept it is fully entitled to carry out an evaluative exercise on, but also the evidence that can be reasonably be expected to be available, and I emphasize, at trial and not at the interlocutory stage. So we say that there's nothing in any of the legal principles requiring a party to put all of its cards on the table at an early stage of proceedings. That approach, we say, is wrong in law. It's also manifestly procedurally unfair in denying the appellant the proper right and opportunity to provide that evidence through normal case management. The simple question for the judge also would be whether there was a reasonable expectation that witness evidence could have been made available at trial. We say that his conclusions at paragraph 49 of the judgment impliedly accept that that was the case, because he says, apart from the power of attorney and without evidence of the A list, there is nothing to warrant the finding. But the necessary inference from that is that had the witness evidence been before him, that would have changed things, and that in itself is enough to dismiss an application for immediate judgment. And we say that is precisely what should have happened in this case. My lords, that's all I have to say at the moment. Hopefully that should give some context as to why we say there are factual issues in this case and why further investigation is required, linking the factual issue to the legal issue under Geomatic.
Okay. That's it, Mr. Doty?
Yes.
Okay. How long are you to take, Mr. Thompson? How long do you expect to take?
Hopefully not too long. I mean, obviously, I want to be able to address any questions from the bench,
Yes.
but I would say just left to my own devices, probably something in the region of half an hour, maybe 40 minutes. But and that's subject to be able to find all the pages. I know we all seem to have slightly different bundles. So. But I don't know if your lordships want to take a short break now.
Are you ready to continue, judges? Continue?
Yes.
Okay.
Yes.
Please.
I'm happy to continue. Well, I'm grateful. So I'm going to stick to the three broad topics that were set out in our written submissions. And hopefully, as I address those submissions, I will pick up all the points that your lordships asked Mr. Doty, and indeed in response to Mr. Doty's new submissions. As a broad point, I would say, with respect to Mr. Doty, that he didn't address head-on the questions which were posed to him by the bench, and I will explain what those answers to those questions are and why it is Mr. Doty can't actually answer them straightforwardly. I have sympathy for Mr. Doty, given the position he is in. But the first broad topic is the procedural question of what a respondent to an immediate judgment application ought to do. Listening to Mr. Doty, you might get the impression that what a respondent need do is nothing at all, because his submission, and he encapsulated it right at the end there, was that there's no obligation to put your cards on the table. At the risk of stretching the metaphor, there's an obligation to put the cards on the table which you have in your hand. There might not be an obligation to go and hunt around for other cards that you might have lying around and which you might be able to put on the table later, but you can't keep your cards in your hand if you have them at the point of immediate judgment. That point is abundantly clear from the authorities. My learned friend took you to two authorities we have cited. I will take you to one he has cited. At Bundle 9, tab 12, and you'll forgive me because I think, Chief Justice, I'm going to have a different page reference from you. There is a case involving this company, or at least an associated company of this one, called Investment Group Private Limited and Standard Chartered Bank. It's the very last authority in the claimant's bundle, tab 9. I have it at 9-198, but I fear that
9 again. Sorry, 9. Sorry,
9-198. I strongly suspect it's not where you have it.
Yeah, that's the current numbering.
19.
I think you should be all right.
Investment Group Bank and Standard Chartered. Yeah, I got it.
Oh, good. Right. Well, that's lucky. So this is a case which is cited by my learned friend both in the court below and at the hearing last time, and indeed in a footnote in the skeleton this time. So he relies upon this authority, and it's a decision of this court in this jurisdiction. So there's no better authority on the point for present purposes. If you go forward in this judgment to paragraph 57, which is in my bundle at least 9-207, you can see the court there, this court, addressing the test for immediate judgment. This is a section that my learned friend expressly relies on. And you can see at paragraph 57, if you have it, the test for immediate judgment is whether IGPL had no real prospect of succeeding in defending the bank's claim, SCB's claim. And there the familiar references to Swain and Hillman and the GFH and David Haig case. But it's 58 and 59 I invite you to look at. 58, while the legal burden of proof for immediate judgment rests with it, SCB submits that the evidential burden of proving that IGPL, the respondent, has a real prospect of successfully defending SCB's claim rests with IGPL. I agree with SCB. The case of Korea National Insurance Corporation and Alliance Global Corporate and Speciality provide some useful guidance as to a party's evidential burden of proof. In Korea, Lord Justice Morbick opined that if a party wished to rely on the likelihood that further evidence would be available, it must substantiate the assertion. It's insufficient to simply say that further evidence will or may be available. The relevant excerpt is as follows. And I'd invite your lordships just to read that passage from Lord Justice Morbick's judgment in Korea in italics in its entirety.
Yeah, that's what I was driving at Mr. driving at Mr. Doty just now, a couple of times.
Yes, and it's a complete answer to the questions which I think your Lordship Chief Justice asked Mr. Doherty. It obviously cannot be right that a respondent to an immediate judgment application can just sit back, put no evidence in at all, do nothing at all, and then say to the court, well, I have no obligation to put my cards on the table. I don't have to respond to his application at all. There will be more at trial. I'm not telling you what it is. What the respondent has to do is to satisfy the court that it has a real prospect of putting forward other evidence. And all the cases say that. And this is the phrase that Mr. Doherty skirts over whenever he looks at the authorities. The authorities sometimes describe it as evidence which is likely to exist, but more often reasonably to be expected to be available. And here you can see in the Court of Appeal decision I'm showing you at 59, the test is the likelihood that further evidence would be available. And it's for the respondent to substantiate that assertion. And so it was prescient when the Chief Justice asked Mr. Doherty, well, what evidence is it that you're talking about? And Mr. Doherty, for the very first time, he didn't say this to the judge below, tried to indicate what he thought might be available. It slightly seemed to be a slight moving feast, but it seemed to be that Mr. Doherty was suggesting that what would be available was some explanation in witness statement evidence of the documents that are already before the court. Well, in which case, the immediate rhetorical question that would come back to the respondent is, well, why didn't Abdullah do that below? He must have some explanation of why that will be available at trial, but isn't available today. To that question, there is no answer at all from the appellant. And the answer to it is that if the reality almost certainly is that if there were some answer, Abdullah would have put it forward. If he has chosen not to put forward some answer he actually has, well, then he can't criticize the judge for not taking it into account, because the judge is entitled to ask, well, am I satisfied that there is likely to be further evidence available at trial, which for some reason has not been put before me? And there has to be some reason why it hasn't been put before the judge. Rather, what Mr. Doty does in his skeleton argument is to elevate the test on an applicant for immediate judgment and depress the burden put on a respondent to immediate judgment. At paragraph 31 of his submissions, he says, wrongly, I suggest, that it is not expected at an interlocutory stage that the party will have full evidence that may be available at trial and must approach the application for immediate judgment with utmost caution, and then goes on to say that this is an exceptional jurisdiction. And at 31.3, the biggest error in the submissions is that he says there's no authority requiring the respondent to bring forward its investigations or case preparations, but there is authority requiring the respondent to satisfy the evidential burden of proving that it has a real prospect of success, and if the basis on which it wishes to satisfy that burden is by saying there is a likelihood or reasonable prospect for other evidence to be available, then to satisfy the court, the respondent will have to explain what sort of evidence that is, why it will become available in due course, and why it can't bring it forward at this point. And I should say parenthetically, the appellant in this case actually asked for an extension of time to put in evidence before the judge below. There was no pressure upon it. It said we need more time to put in the evidence. It put in reams of evidence, just not anything on what it now says is a critical point. I've cited other cases in England, including King and Stifel, and the Litt case that my friend referred you to, and ICI itself, and indeed Royal Brompton, which you'll all be familiar with, but they all say the same thing. And the point which my friend is skirting over is this question of what is reasonably to be expected may become available. The judge below, for what it's worth, got this absolutely spot on. So you can see in his judgment, which is tab 1.3 or tab 3 in bundle 1, at page 1-15, the judge here in paragraph 21 of his judgment was setting out the law on part 24 of the RDC. And you can see he summarizes the principle in that paragraph, and 5 lines from the end, can you see the judge says the court must take into account not only the evidence before it in the application, but also the evidence that can reasonably be expected to be available at trial. That is, with respect, precisely the right question. He then goes on at paragraph 63, albeit in a slightly different area, to apply that test to the evidence. And in paragraph 63, where he's actually dealing with implied authority, we'll come back to that, he says 4 lines from the end, there is no reason to think that other significant evidence not presently available to the claimant might exist and could be available at trial. And then in considering the permission to appeal application, which was made before him, you can see at tab 7, page 18, so 7-18. I hope everyone has that same reference as me, but it's the schedule of reasons given by the learned judge below. You can see that he returns to this precise test and says, in addressing ground 5, he refers himself back to paragraph 63 of the judgment, which I just read to you, and then he says at the 3rd line down, no particular further evidence is identified in the claimant's submissions. The circumstances of any use of the power of attorney were entirely within the knowledge of Abdullah, Muhammad and Majid. They could have, but did not, give evidence in the application for immediate judgment. Having chosen not to lead evidence from them, the claimant cannot be heard to say that their evidence for the purposes of the application is further evidence likely to be available at trial. And I was not satisfied that there was otherwise material evidence going to Abdullah's authority unavailable to the claimant and likely to become available. And there was no hint in the hearing below as to what that evidence might be. In fact, I think the first answer to it has been today. So if the judge wasn't given any basis to be satisfied that there was other material evidence likely to become available, he cannot be accused of getting the application of that principle wrong, a principle which he expressly sets out correctly. That should dispose of the appeal on its own. But even if I were wrong about that, in fact, it is clear, I'm turning now to my second heading in my skeleton argument, even if I was wrong about that, it wouldn't make any difference, because ultimately, as your lordships pressed Mr. Doherty on, this is a question turning on a very narrow application of the law of authority of shareholders of companies. And Mr. Doherty was forced to rather skirt around the problem he has here. He does it initially by reference to Mr. Giles's, to Mr. Justice Giles's decision at paragraph 49, but for reasons I'll come to, he's reading the wrong section, or maybe more accurately, he's reading it out of context. But the problem for Mr. Doherty is that any authority that Abdullah might have had to act on behalf of the company can only be derived from somebody who has the power to give to him. It cannot be just dragged out of thin air. So that is why we say, if I am wrong on the first appeal, and in fact Majid and Mohammed had some power to bind the company as shareholders in a general meeting in relation to tenants agreements or agreements with third parties, then we accept, for the purposes of this application at least, that power could have been donated through the power of attorney to Abdullah. If you agree with Mr. Doherty on that point on grounds 1 to 3, then this appeal will succeed and the matter will go to trial, and the Al-Saris can put in whatever evidence they wish to do in due course. But if conversely you accept my arguments that I made in January on the grounds 1 to 3, that Mohammed and Majid didn't have that authority at all because of the way the memorandum and articles of the company work against the legislative background in the BVI, then there's nothing they could have donated to Abdullah, and the point is entirely moot. Now, Mr. Doherty tries to skirt around this by saying, well, it's a different application of the Geomatic principle, because it could be that the shareholders somehow create some authority in this agent, which is distinct from their own power to manage the company. But that's just playing with words and isn't actually any reflection of the law. If you go back and think about what Lord Hoffman and others have said about companies, they are obviously simply legal constructs. There needs to be a human agent to act for a company. And under the common law, the two possible bodies of human agents which can act on behalf of companies are directors by a board and shareholders in a general meeting. But as we debated in the January hearing, there is a delineation between the powers and rights of those two institutions, the board of directors and the general meeting, and that is the problem with the first appeal. There is no other form of institution that the company can use to carry out its practices. If it is said there is an agent and the agent acts on behalf of the company, the question becomes, well, an agent of which institution of the company? And this is why Mr. Doherty's argument on ostensible authority, for that is what it is, actually fails. See, what Mr. Doherty would have you believe is that Abdullah was somehow authorized to act on behalf of the company by Mohammed and Majid as shareholders, but without Mohammed and Majid themselves having that power. And somehow there's an ethereal power that the company has that has devolved onto Abdullah, but not going through the shareholders. It is at its highest, Mr. Doherty's argument is at its highest an argument about implied authority. The difficulty with Mr. Doty's argument is that implied authority was something which the judge rejected at first instance. It's in his decision from paragraphs 51 to 63 and expressly at 61, and is not, and that's not a finding that's been appealed. So merely from the perspective of the appeal process, this isn't something which is open to Mr. Doty at all. At 61, Justice Giles said, in my view, the claimant has no real prospect of establishing implied actual authority in Abdullah to sign the tenancy agreement. There's no substance in the argument. And the argument which was put before the judge below and which Justice Giles dealt with in that section is precisely the one that Mr. Doty is now trying to resurrect, that there were other acts going back in time which demonstrated that Abdullah somehow had the authority, ostensible authority in the eyes of third parties to act on behalf of the company. But the problem, even if he were allowed to run this argument in this court, even if he had put this forward as a ground of appeal, which he hasn't, then it would still be bad, because the principle of ostensible authority is that a third party has some grounds for believing that an agent is authorized by the principal. If the third party just assumes that an individual is acting on behalf of a company, there's no ostensible authority. The ostensible authority principle must be derived from some objective basis on which the third party can conclude that the agent did have the actual authority of the principal. So that being the case, the question in this action would be, what is it that anybody dealing with these BVI companies would find to justify their conclusion that Abdullah was authorized to act on behalf of either the directors or the shareholders? And the answer to the first question is there's nothing to justify the idea that he was acting on behalf of the directors. Indeed, this List A and List B point rather undermines that whole argument, because the whole point of List A and List B was that there was always going to be a director who signed. The fact that a bank might have wanted two signatories is just for their own internal purposes. But there isn't any basis on which it could be said that a third party would think that Abdullah was authorized on behalf of the shareholders, save for that argument you've already heard in January, which is why the whole argument boils down to the same argument which you heard in January about Majid and Mohammed and their power to bind the company qua shareholders. Turn then to paragraph 49 of Justice Giles' judgment, because this is where Mr. Doty seems to put all his eggs. The problem with Mr. Doty's submissions is he's reading this paragraph entirely out of context. If you start about 7 lines down in paragraph 49, which is 1-24, the judge said this: let it be assumed that Mohammed and Majid informally resolved that the defendants should enter into the tenancy agreement. Apart from the power of attorney, and in the absence of evidence from any of Mohammed, Majid and Abdullah, there is nothing to warrant finding that they informally resolved that it should be signed by Abdullah on behalf of the defendants. That's where Mr. Doty puts all his eggs. But the next sentence is critical. The power of attorney is the essential link to that appointment of Abdullah, but it is a false link. It empowers Abdullah to act on behalf of Mohammed and Majid, not on behalf of the defendants. Put another way, in the claimant's reliance on the power of attorney as embodying Abdullah's authority, he signed the tenancy agreement not on behalf of the defendants, but on behalf of Mohammed and Majid. To say that he signed on behalf of Mohammed and Majid in their capacity as beneficial shareholders does not work, because signing is not something for them in general meetings of the defendant. This is a fatal flaw in finding authority in Abdullah in the exercise of the powers of Mohammed and Majid as the beneficial owners. The claimant having conducted this application without evidence from Abdullah, Mohammed and Majid, there's no reason to give it the opportunity to improve its position, or sufficient reason to consider that further evidence which will improve its position can be expected to be available at trial. The point the judge is making is that the power of attorney does not work as a matter of law. And that's why he's saying there's no evidence which could solve this. He is saying in this paragraph, there isn't any evidence, and what's more, there couldn't be. It is a problem of law, and that is what we were debating in January. And so to suggest, as Mrs. Doherty does, that actually the judges here is suggesting that there might be more evidence available is just wrong. Ask yourself this: what is it in this section in paragraphs 49 and 50 that the judge could possibly have thinking might exist, what evidence might exist that would save the appellant's position? The judge is here saying that there is no authority given to Abdullah on behalf of the companies, and there's no evidence of that. But effectively, he's saying there couldn't be any evidence of that. As I say, it's impossible to imagine what evidence there could possibly be. It cannot be, just to finish the point, it cannot be evidence of some ostensible authority, because that is a section that the judge deals with on the very next page. In fact, the next paragraph of 51. So it simply doesn't work. And I think it's for that reason that we conclude in our written submissions that this additional ground of appeal simply doesn't assist or doesn't affect the outcome of this appeal either which way. Obviously, your lordships have heard us on the primary point argued in January, and as we have said, and as Justice French has indicated, our point on that is pretty narrow. It is necessary and sufficient for the appeal to succeed that Mr. Doherty persuade you that actually Mohammed and Majid could operate in a way as shareholders to bind the company in executive decisions with third parties. If he is right about that, this appeal succeeds. If he's wrong about this, ground 5 simply doesn't help him at all. And so I think I'm just picking up anything else that Mr. Doherty said that I ought to respond to. Mr. Doherty said this was a distinct and different application of the Geomatic principle. He is splitting hairs. It isn't a different application at all. The application is exactly the same. You've seen the extracts from Mr. Justice Neuberger's decision and from Geomatic itself before, and it is evident that what Geomatic is concerned with is resolving problems of formality when shareholders do have some particular power but don't operate it at a formal general meeting. In those circumstances, they can operate it informally. They don't have to operate it together or simultaneously, but they do have to operate it unanimously. Mr. Doherty then focuses on the question of vires and it needing to be intra vires. That is obviously true, but that is only the start of the inquiry, because in Geomatic, it must obviously be intra vires, but the power must also be one that actually resides in the general meeting in the first place, as in Geomatic itself, where the shareholders had to approve the director's remuneration, as in Siban, where the shareholder himself was directing an agent to tell the directors what to do, and indeed as in all the Geomatic cases, where the real question is the interrelationship between the shareholders in a general meeting on the one hand and the board on the other hand. None of those cases give any succor to Mr. Doherty in his submission that the shareholders somehow have a right to take over the management of the company in circumstances where there is a perfectly functioning board of directors or single director which is capable of doing it itself. And I've already made my submissions on that in January. It would be a recipe for disaster if shareholders.
Mr.
Apparent.
Thompson,
Yeah.
he cited certain practices where by signing the tenancy agreement and loan agreements, they were already acting on behalf of the directors of the companies, the corporate director of the BVI companies. And therefore, he says, by practice, that people have accepted that Abdullah and Muhammad have been delegated or given that function to carry out those duties. And he cited 3 or 4 examples. What do you have to say to that?
Yeah, well, in relation to those examples, we ought first of all to discount the tenancy agreement itself. That is the subject of this case.
There's 2 other examples.
We can ignore that one. As for the Coutts letter, firstly, that wasn't signed by Abdullah. It was signed by Muhammad. But more importantly, it was actually signed by Air. It was signed by the director. Now, obviously, very often banks will say, well, we need to have a mandate. We need to have the authorized signatories who can act on behalf of this company. In this circumstance, the bank, Coutts, obviously required 2 signatures, but one of the signatories was the director of the company. As a matter of law, that director on his own could have bound the company. The fact that the bank wanted 2 signatories is neither here nor there. So the second signature, that of Mohammed or Majid on the bank's documents, doesn't assist Mr. Doherty one jot. The settlement agreement is a bizarre document that has been contested one way or another in the Sharjah courts, and we don't accept that it has any great significance anyway. But frankly, 1 or 2 documents do not make a course of conduct, and certainly don't suffice to establish some basis for finding that Abdullah, and it must be Abdullah, had ostensible authority. But as I've already said, the ostensible authority question, which is the only thing these documents could possibly go to, is not under appeal. The judge rejected that argument, and it isn't under appeal. And as I say, even if it were under appeal, these examples would be inadequate to satisfy an appeal on that basis. It hasn't been properly put before you in any event. But this is all entirely academic, because this is the Court of Appeal. And so in order for Mr. Doherty to succeed on this ground, he would have to persuade you that the judge's approach on this very issue was wrong. And as I've explained, the judge got the principle right, applied it correctly, and said, as was obviously the case, that he had nothing before him that could satisfy him that there was likely to be further relevant evidence on this point. It wasn't even addressed on the point. I think that's just over half an hour, but I think those are all the submissions I have to make. I better just check on my electronic device to see whether I've got any emails in the meantime. I don't think I have. So unless I can assist the bench in any way, those are my submissions for the respondent.
Any questions for the bench? No?
No.
Okay, can Mr. Doherty, I'm sure you're not going to take very long, Mr. Doherty.
No, just a couple of short points.
Okay, please.
My lord. The first is in respect of the phrase repeatedly referred to by my learned friend that I was said to have been skirting around, which was the likelihood that evidence is available. I say it's somewhat ironic that my learned friend accuses the appellant of skirting around that issue in circumstances where he has repeatedly expressed that statement without the key and what we say are operative words at the end of that sentence, which is the court is bound to consider the evidence that is likely to be available at trial. And that is the formulation in GFH, it's the formulation in Royal Brompton, in ICI, in Arcadia, in Easy Air, the list goes on and on. The point is that the judge is supposed to be looking at evidence that is likely to be available in the future. What we say the judge has done in this case has got it the wrong way around, because what he is asking is what evidence is available now and why isn't this available now? And we say
but
approach.
To be fair to the judge, Mr. Doty, you must give him some indication what the evidence are going to be before he can sort of say that I will allow you to produce more evidence. And your evidence are only the two documents which or three documents which includes the tenancy agreement itself, and there are two other documents, the signing of the loan agreement, but that has been shot down by Mr. Thompson just now. So you are sitting as a judge. How do you assess what is it that the evidence which Mr. Doty is going to produce at trial if I were to allow the matter to go for trial? I mean, put yourself in the position of the judge.
Well, with respect, my lord, the position is this, which is that the judge had before him at first instance the power of attorney, which is evident, but it's also the fundamental document in support of the proposition that Abdullah had the power to sign. We have three separate documents which show that over the course of a 5-year period, Abdullah was acting as a signatory for the company. And we have witness evidence from Mr. Colin Denvers as to heirs' inactivity in the affairs of the company. We have his witness evidence as to the habitual practice of the A-list, signing documents and signing formally matters which were matters for the company. And we have that taking place over, I think it's a period of 7 to 8 years. Now, in that context, and in the context of the appellant's legal submissions as to authority, the question for the judge, and sorry, I should add that has to be set against the paucity of evidence provided by the respondent on its own application. And the threshold test is structured in a very deliberate way to require the applicant, in that case, to overcome a high threshold. In this case, we have an entirely one-sided picture where all of the evidence that's being provided is being provided by the respondent. We say that on its own, there is more than enough there to make it a triable issue. In any event, we have the legal submission based on the principles governing this type of application, which say that in any event, where there are complicated issues of fact and law, they are not appropriate for summary disposal, and we say this wasn't a short point of construction. The question for the judge then at that juncture is, well, is it reasonable to expect that these witnesses will attend and give evidence at trial? And we say that the answer to that is yes. It doesn't matter what the specific contents are, if that evidence can reasonably be expected to be available and be relevant to the questions before the court. The proper course at that juncture is to deny the application for immediate judgment. The second point in response relates to the second part of paragraph 49 of Justice Giles' decision, which my learned friend referred you to. What the judge is effectively saying there is that the legal analysis of Abdullah signing, standing in the shoes of a shareholder, the tenancy agreement doesn't work, because the act of signing the agreement isn't a matter for shareholders. Now, that is actually the issue that's under appeal in grounds 1 to 3, because what we say is that the judge there has misconstrued what the appellant's primary case was. The question before him wasn't the question of formalities and whether Abdullah could sign. The question on that issue is whether Abdullah's act in itself was sufficient to stand as an act of a shareholder, binding a third party. So that's the narrow legal issue on grounds 1 to 3. The first part of what he says at paragraph 49 cuts at a distinct question, which is whether, had there been evidence that Abdullah had been authorized by the shareholders to sign, and I stress the words he used, on behalf of the BVI companies, that would have been different. So the question is, in one analysis, if he signs on behalf of the shareholders, that doesn't work as a legal analysis. But what he's saying above that is that it could work on the legal analysis and on the application of Geomatic if he's signing on behalf of the BVI companies, and if that's what the resolution of the shareholders goes to. And that's the key distinction between what we dealt with in grounds 1 to 3 and what we're dealing with now. And we say that the evidence that I've already referred you to and rehearsed goes to that issue. And that's why there's, even on Justice Giles' framing of that issue, an issue to be tried. The final point on that I make in reply, it really raises some of the points raised in respect of Geomatic, which I think apply to both this appeal and also to the appeal you heard in January. What we say is that the respondent in this case adopts an unduly narrow view of how that principle operates. And I remind the court that when we addressed this back in January, I took the court to extracts where the Geomatic principle is described as being one of the primary rules of attribution for companies. It's not one which is subservient to the normal operation of a company operating through its directors, but sits alongside it. And what we say about the respondent's view of the Geomatic principle is that it looks selectively at the authorities in order to adopt an application of that principle that is so narrow as to render the principle largely redundant, because what is effectively being said is that, well, unless a company operates through its articles of association, an act can't be an act of a company. But that's precisely not what Geomatic says. And I've already referred your lordships to some of the authorities in those issues. But as a short reminder, I took you to the Meridian case back in January, and that was authority for the proposition that anything which a company can, under its memorandum of association, do, or has the power to do, where that act is taken by the shareholders, it is a decision of the company. So that's saying that if it is something which is not expressly excluded by the memorandum of association, shareholders' acts are acts of the company, even if they fall outside the normal mechanisms of the operation of the company in the company's articles. And the second case, which related to power to transact, even where that power doesn't exist in the articles, was the express engineering case, which you might recall was a case where a number of corporators, shareholders, had got together, appointed themselves as directors, and in that capacity as directors purported to transact property belonging to the company. In this case, it was the issuance of debentures. And the analysis in that case was it failed as an ultra vires act in their capacity as directors, because under the company's articles, which ordinarily empowered the directors to transact, they weren't permitted to do so in a way where they were an interested party to the transaction. But the way the court salvaged the transaction in that case was to say that they nevertheless can have been analysed to have acted unanimously as shareholders, and that in doing so, the agreements entered into fell to be treated as good as if every formality had been carried out. So the point there is that shareholders acting unanimously and so acting can bind the company with third parties, and they can bind the company outside the normal mechanism of its articles. That becomes the binding act of the company, and that's precisely the scenario we're looking at in grounds 1 to 3, but it's also relevant here. So one can say that even if we're not looking at the formal provisions in the Articles of Association regarding the appointment of officers, it would have been open to the shareholders to informally pass a resolution, or indeed formally pass a resolution appointing Abdullah as a signatory on behalf of the company, not on their behalf as individuals, and that resolution would become binding upon the company such that it was then bound when Abdullah ultimately signed the tenancy agreement. And we say that that's not really much different to if one looks at the position under the company's articles, where the shareholders, acting unanimously, could have taken the step of appointing Abdullah as a director for a period of time, and thereby authorizing him to sign the document. So we're talking about something which is different on the facts. It involves similar applications of the Geomatic principle. which we say is a broad application. Those are the only points I wanted to raise on reply.
Yeah. So that's it?
Yes.
Okay. Thank you very much, Mr. Doty. It's 5:15. So, Mr. Doty and Mr. Thompson, thank you very much for your very enlightening, very useful submissions. So we will reserve our judgment. We'll come back to you with our decision. For now, I'll adjourn the court. And Mr. Justice French and Madhani, can we go on to the other link? Discuss. So thank you very much again, Mr. Doty and Thompson, and all the backroom
I'm grateful.
people.
Thank you.
Thank you.
Thank you.
Thank you, Grateful.